Hello everyone and welcome to today's Mondac webinar in association with MRP Advisory, where we will be discussing how to deal with various important issues faced by construction contractors in the Middle East. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Rishabh Jogani is an India qualified lawyer with several years of experience. In addition to construction law, he specialises in shareholder disputes, intellectual property law issues, debt recovery claims and real estate matters. He regularly advises clients on various legal issues. He has represented clients in both domestic and international arbitrations. Sean Brannigan KC is one of the leading stilts at the commercial bar and is renowned for his exceptional advocacy, particularly across the practice areas of energy, construction and engineering and professional negligence. He is most regularly instructed in large-scale international and domestic litigation and arbitrations where teamwork, together with detailed and effective cross-examination and other advocacy is required. John Fletcher is a managing director in the expert services practice of Kroll LLC, based in the Dubai office. He is a mechanical engineering professional, expert advisor and delay analyst with over 15 years of experience in the design, construction, analysis and management of major projects throughout Europe, the Middle East and Australia. And finally, moderating today's session, Sharda Srivastava is an international dispute resolution lawyer working with MRP Advisory Dubai. She has vast experience in handling complex construction arbitrations across continents. Her expertise lies in industries like infrastructure, engineering and power and energy. She's represented clients in both domestic as well as international arbitrations. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible. It's now my pleasure to hand you over to Sharda to begin. Thank you.
Thank you so much, Dan. So basically talking about the project-related correspondences that are maintained by the parties. So my question would be to Rishabh. In your experience while preparing pleadings in a construction dispute, I see there's a great reliance upon the project-related correspondences. So how do you see, is it usually maintained by the parties, and do you see that there's a trend among the parties that they've been using some sort of software to communicate contemporaneously, and is that helpful while collating the documentary evidence at the time of preparing any pleading in a construction dispute?
Thanks, Sharda. Well, very often, at least in the Middle East, I've seen that there's not always a great amount of record keeping. And if there is, I'm talking about, at the level of, that would be ideal. But very often clients have started using softwares like Aconex, for example, and which keeps the data in a very sensible manner. Then when lawyers do come on board, it's easier to get that information, because increasingly I'm seeing cases where clients may have sent notices and letters or correspondence, but would not have a good record of it. Also, when it's all in paper format, especially pre-COVID, it's very hard to actually find the data that you're looking for, because it could be a large project, it could be thousands of letters. So if it's electronically saved somewhere and properly arranged in the beginning itself, it makes it possible to actually make a good claim, because you may send a notice, but it's of no help if your lawyers don't get a copy of it.
That's very helpful. From a pleading point of view, I see how a software could have been very helpful for storing the correspondences in an electronic manner. A similar question would be to John. I understand, would want to understand from an expert's point of view. In your experience in construction contracts, how have you come across, how are the project records maintained in the Middle Eastern region in terms of, say, if the parties want to record the completion of work status, etc., and all those things that become relevant when there's a expert's analysis for delay, etc.
Yeah, thanks, Sharda. So for me, the first thing you need to consider is how the progress is actually recorded. So, everyone says, well, progress is progress, right? Well, no. Are people recording physical progress as a programming and delay expert perspective? That's the most important thing to me. Where was the physical status of the works? However, if you're a contractor or the commercial manager running your project, you're going to be more, you're going to see things a little bit differently and would be more interested in, the cost and potentially the value of works completed. And so a lot of times we'll see on projects being run and managed in terms of what we term earned value, on the cost that's assigned to the works. And this can be great for a contractor trying to generate cash flow, and they can do that by ordering, large expensive items of equipment, placing them and installing them and getting that signed off. And then you can say, well, look, I've done 50% of the works, based on value, right? But that doesn't mean that you're actually 50% of the way through. And so you can see now the disconnect happening between physical progress and time and cost, because what then takes time, connecting all of that plant and equipment together, could be what takes maybe 70% of the time. And so actually by installing the plant, maybe they were more like 20 to 30% complete. And so we regularly see projects being run and managed based on earned value progress, which ends up a lot of the time leading to people starting everywhere and actually finishing nothing, right? So if you take a nice big high-rise tower, there's plenty of those in the Middle East. If you were to start and make do the simple easy work on every floor, cash flow would be great. Everybody's thinking you're making great progress, but unless you're actually finishing certain trades, the next trade actually can't progress, and so you're not actually progressing as quickly as you would like towards the completion of the project. And there's actually another way in which progress is sometimes recorded, which is budgeted man hours, similar to cost, but hours are then assigned to an activity. And then as those hours are used up, that's counted, as, again, progress. But, if you're inefficient or you put lots of men, on an activity, and you may use up those hours, that doesn't necessarily translate to progress. And so a project I was working on in Saudi recently, it was all done on budgeted hours. They got to a point in time when they said, oh yeah, we've used up 50% of the hours. If you went and looked out the window, that project was definitely not 50% complete. And that ends up being, at the start of a project, everything might be fine, or feel and seem fine, but a big problem is going to happen down the line. And I think probably the last thing to touch on in terms of progress and progress records would be in the Middle East region. We have work inspection requests, and these can be particularly helpful because they're not just one party's position as with regard to progress, but it's actually a really helpful record in that the engineer or consultant has also signed off on those. And so you can use work inspection records, particularly from a arbitration dispute forum, because they're a nice solid hard piece of evidence that multiple parties have all signed, and so there's no debate as to actually when an activity or task was complete.
Right. That's very helpful, John. In an ideal situation, that's how project records should be maintained. But just a follow-up question to Rishabh, I would want to understand from you that in your experience, how should a party who has had poor record keeping try and make a claim for EOT upon project completion?
Thanks, Sharda. I think it's not the best situation to be poor record keeping, but at times we need to work with what we have. And I've seen, at least in the past, what we've been doing is we get in the relevant person, maybe the project manager or the construction director, and have them at least put down a witness statement and then collate the records that are available, be it minutes of meetings or invoices. Very often you'll at least have financial records, and try and create the case on that basis. It's not the best situation. I'm not advising anyone to work that way, that you should not be sending out notices or not be corresponding, but that's what you eventually have to work
with. Thank you, Rishabh. We understand that what complements the documentary evidence would then be the witness statements or the expert statements, which help in substantiating a party's case. So I would like to understand from Sean, since you also sit as an arbitrator, how do you weigh the different types of evidence that are placed on record by each party in terms of the expert evidence, witness evidence, and also the documentary evidence?
Thanks, Sharda, and welcome to everybody who's joined us. Can I turn around the question a little bit, because I suspect what most people watching aren't that interested in how I personally would weigh the evidence. I think what they're probably more interested in is a wider discussion as to how arbitrators as a whole would. It seems to me that any discussion or any seminar like this needs to concentrate really on the practicalities of what we're talking about. Anybody joining is really interested in, well, look, how do I win my construction dispute in the Middle East in particular? And I think it's important to recognize that the question is not an academic one, it's an intensely practical one. And sort of take it in layers. You win your dispute by convincing the arbitrators in front of you that you're right and the opposition is wrong. It's important to recognize that all that really matters is not the view of the lawyers or even the view of the witnesses, but the view of the tribunal in front of you, the three people you've asked to resolve the dispute. Sometimes one person you've asked to resolve the dispute, but in the Middle East, most often three people. And it's important to realize as well that those three people may well, depending on the legal tradition they come from, approach the weighing up of documentary evidence versus witness evidence versus expert evidence very differently. So, for example, if you have somebody from a civil law background as one of your arbitrators, a Swiss arbitrator or an Italian arbitrator, and they're weighing up the documents versus live evidence, the weight they will give the documents will be almost overwhelming. If the documents tell a particular story, then the fact that witnesses might turn up and try and present a different story will really cut very little ice. If you have somebody from a common law background, a barrister, say, from England or Ireland, or somebody from Singapore, or somebody from Australia or New Zealand, then they are likely to regard the live factual evidence of witnesses as weighing quite heavily, much more heavily than somebody from a Swiss law background would. So the starting point is to recognize, well, who am I trying to persuade? What are their legal traditions? Have they written anything in the past by way of the judgments I can look at with a weight of evidence? Have they written any articles that I can look at where they have indicated their approach to weighing of evidence? And then tailor how you present the evidence and the weight you put on different strands of evidence differently depending on who you are that you're trying to persuade. Having said that, I think there's certain universal principles, and I always regard the process of putting together the evidence and weighing it up as a pyramid. I view it as a pyramid rather than a set of scales. The foundation of the pyramid is, in virtually all cases, the documents, pulling together the documents and explaining the documents, putting them in a coherent way. As part of that, it's quite important to remember that not all documents are created equal. Most arbitrators, the overwhelming majority of arbitrators, will recognize, if you explain it carefully to them, that, for instance, something said in formal contractual correspondence may have less probative value than something that is said in a candid email that's sent internally from one bit of your client to another bit of your client. We've probably all done cases where the correspondence tells one story and the internal emails, WhatsApp messages or WeChat messages tell a very different story. So whenever you're putting the documents together, I think it's really quite important to both understand the universe of documents as the foundation of this pyramid, but also understand that not all documents are created equal in terms of how much they're going to persuade an arbitrator. In a way, contractual correspondence is the lowest person in the totem pole. What's much more important, as I say, is internal correspondence, which most arbitrators will presume to be much more candid, and meetings of minutes. If there's a meeting that's minuted with either both parties signing the minutes or minutes being sent out and nobody taking issue with them, 95% of arbitrators from all jurisdictions are going to give those minutes really quite significant weight. The layer above that in the pyramid is the witness evidence. That witness evidence, though, should be tied very closely to the documents. You need to understand, when putting forward witness evidence to a tribunal, whether that witness evidence is consistent with the documents, and if it's not, you need to explain why. For instance, it may be your witness will need to explain, I know we said this, i.e. that there was no delay being caused by design issues in a document to the employer, but in fact that's because I was worried about a claim coming down the line, and really the true story you can see in the minutes we were putting forward to our subcontractor who was dealing with the design. So you need to be able to identify and explain to the arbitrators what the documents really are saying, particularly if there are documents which are not helpful. And I personally think ignoring the unhelpful documents and just hoping they won't come up is a poor strategy. You're going to get somebody who's going to find the documents, look at the documents, and if you haven't dealt with them in your witness evidence, it's going to hurt you. The very top layer of the pyramid, by which I mean the bit on top which does not hold up the rest, is expert evidence. But I put that at the top of the pyramid not because it's the most important, but because it's the least important. In my experience, if you're going to convince arbitrators of something, particularly as to factually what happened, pretty diagrams from delay experts won't cut it. Those diagrams can be useful as a way of pulling together the bottom two layers of the pyramid beneath it and explaining them in a coherent way. But if the delay evidence says something different than what the factual witnesses say, and even more importantly, if it says something different than what the documents show, then most arbitrators are going to look at that delay evidence and think, well, that's not really worth very much. That's particularly the case in the Middle East, where I think quite a lot of arbitrators from Sharia law traditions and backgrounds have, and I would say to some extent, a justifiable sense of cynicism about delay expert evidence in particular, but also some other forms of delay evidence. I don't think I've ever won a case on the basis of my delay evidence if that delay evidence is inconsistent with what the documents actually show. And in that way, people who are doing arbitrations from a Sharia law background are very similar to those from, for instance, a Swiss law background. There's a lot of overlap. So the summary is you've got to recognize the horses for courses. You've got to work out, well, really, where's my arbitrator coming from in terms of what's going to convince them in relation to the evidence. And then within that, you've got to recognize that in most cases, you've got to build your case from the documents up, with the layers of the pyramid above that, either consistent with the documents or explaining why the documents are wrong. And so that's, I think, the weighing up exercise by and large that most arbitrators would do. And it's certainly the weighing up exercise I do whenever I'm sitting as an arbitrator. Does that answer your question, Sharda?
Yes, that was very helpful. I see that one of the most crucial documents at the time of determining the extension of time claim by a contractor becomes the notification document, which is a contractual condition precedent clause. So in your experience, how do you view the contractual condition precedent clause in terms of its strict applicability in the Middle East region? Does it become absolutely necessary? How, from a legal point of view, how important is it in terms of its strict application?
Okay, so as quite a lot of people who are on this seminar today will know, the DIFC court has recently brought out, has recently considered applying DIFC law at least to notification requirements in the case of Panther against MESC. And I think that's probably quite a useful starting point for people to go and have a look at that when they're considering from here on in notification requirements. But I don't think it's the full story. There are two key things. The first is to actually look carefully at what the notification requirements actually say in the contract to work out if they are condition precedent and exactly how much detail and so on has to be supplied. But as virtually everybody who's looking at this seminar will know, in the Middle East, there's a layer of complication above that. There are various aspects of the civil code that all play into the concept of how strictly you construe notice requirements. But if I can cut through it for the purpose of this seminar, in my experience, 80–90% of arbitrators approach this issue in the same way. They will ask themselves the question, if there is notice requirements and they've not been followed, has there been prejudice suffered to the person relying on the notice requirements? And in my experience, if the answer is no prejudice has been suffered by not following the notice requirements, most arbitrators will find a way around the notice requirements if the claims are otherwise meritorious. And if prejudice has been suffered because the notice requirements have not been followed, then most arbitrators, in my experience in the Middle East, will seek to give effect to those notice requirements. Now, that's quite a broad spectrum. It may be for some claims there has been no prejudice suffered and the arbitrators can find a way around that. It may be for other claims prejudice has been suffered because the employer might legitimately say, for instance, well, if you'd notified me about this problem, I would have dealt with it and would have got rid of the problem. So I think the starting point for people in the Middle East looking at notice requirements, after they've had all their excellent drafting about what the law means and how the duties of good faith should apply and what abuse of right means. In my experience, the vast majority of arbitrators, when they retire to the little room to decide it, say, well, that's all great. Those are all the same arguments we've heard before. The real question is, isn't it, has there been prejudice suffered as a result of not following these requirements? And so whenever I'm dealing with notice requirements in the Middle East, both as advocate and sometimes as arbitrator, that's what I think the real question is. And that's how I think the vast majority of arbitrators approach this question. And that's often ignored by people, actually, who don't realize that. Often the debate is all about what does abuse of right mean? Is it the same as the French concept of abuse of right or the Egyptian concept? What does good faith really mean in this context? And all of that is fun and games, and lawyers can make a good living doing drafting on that. But I think people would be well served to recognize that most arbitrators at the end of all of those debates shrug and say, well, if there's a notice provision in the contract, we have to apply it in some way. The real question is, if the notice was not given properly, has there actually been prejudice suffered? Because if there actually has been prejudice suffered as a result of the failure to give notice, the abuse of right points really fall away, because it's not abusing your rights to rely on the notice provision. And the good faith arguments really fall away, because if you have suffered prejudice because your contractor has not served the notice, it's difficult to say really you're acting in bad faith and standing on those rights. On the alternative, if the fact that notice was not given has made no difference whatsoever, really, I think winning an argument that you're not abusing your rights by standing on those notice requirements is hard. And I think it's hard to say you're acting in good faith and relying on those requirements if you haven't suffered any prejudice at all. You knew about this all along. So again, that's how I think most, and all these things I always say, I don't make the weather, I'm just the weatherman. I just report what the weather is likely to be. The weather is likely to be, in terms of arbitrators, if you can't show prejudice as a result of your contractor failing to give notice, then you're unlikely to win the argument. But if you as the contractor have not given notice and the employer has suffered prejudice, then you should work on the basis there's a real risk that those provisions will be applied. That's how I think in the vast majority of cases arbitrators approach it.
All right. Thank you. Thank you so much, Sean. Talking about the extension of time claim, John, I would like to understand from you, while evaluating an EOT claim, what are the factors that help you in determining what would be the suitable method of analysis to be used for evaluating an EOT? And particularly talking about the TIA and the APAB method, in what terms would you say that a TIA would yield a different result than an APAB method?
Okay, so to answer your first question, in terms of choosing a method, well, firstly, I'd look at, is the job live? Is it still ongoing? Or where are we? So if you're right at the very start of a job and it's live, then an impacted as planned will work perfectly for you. It's nice and simple and easy and cheap. If the project's live and ongoing and you're midway through, then we can time impact analysis is really your only choice. If we kind of move forward and we're now after the event, then we've obviously got a number of options available to us. It's important to probably check what the contract says. Sometimes a contract will say that assessments must be done a certain way. That being said, sometimes there's a way around that. If it's forcing you to do a time impact analysis after the event and we know it's going to generate maybe not the best result, so you can take those things into consideration. And I guess I would also sort of say, well, how much time have you got available? As planned, as built is, really, in my opinion, a really strong, reliable method, but it is time consuming. So sometimes we see contracts drafted up where they may be, a giant mall or something like that with 15 different milestones, all with liquidated damages. And so essentially, you have 15 projects. It's a very horizontal project. Everything can progress, largely, in isolation. And so, there's not that much interrelationship between these different, milestones. And so you end up essentially having to analyze, 15 projects, if they've all got liquidated damages associated with them. And if you are having to do that, with a retrospective as planned as built method, that could take a considerable amount of time. And so that'd be another factor, is how much time have you actually got available to you to actually come up with an answer here. Whereas, a time impact analysis or a programming form of analysis may not be perfect, but it's actually going to be able to be done much quicker. And if you're forced into a situation of having to do, as I was mentioning in my example, 15 doing it 15 times, then you can either do it that way, or maybe look at an as planned as built, but pick like one or two, as sometimes has to be the case. You sort of pick some larger value milestones, or maybe the ones that were the most delayed, and then have to try and extrapolate that out, which can be difficult. The quality of records can also be a really big factor in deciding what method. If I've got brilliant programming updates, then I could do a time slice method. But in my line of work, and disputes in the Middle East, most of the projects that come across my desk, they've not gone well, and one of the reasons they haven't gone well is because the progress reporting on the project wasn't as good as it could be. People didn't have a tight handle on exactly where the project was at, exactly what was critical, at the time, and so we find that method is typically not able to be used because the programs either don't exist, as is common, or just aren't of a good enough quality. I think your second question was around time impact analysis being different in results from an as planned as built. So in an ideal world, they would actually give the exact same answer. If you have a program that is perfectly logically linked, if it's been perfectly updated with progress, and if you can see into the future and you know exactly how much delay each event is going to cause, and if you make sure that you not only model employer delays, but you also model your own delays, and so you generate this model that's perfect in every way, then it doesn't matter which method you pick, the answer should be the same. In reality, that's not the case. In reality, the programs aren't logically linked exactly how the project was built. In reality, people don't know exactly how long a delay event is going to take, and typically we also see time impact analyses being done where essentially only events that suit the person doing it are actually put into the model, and as a result it's not fair, it's not balanced, and therefore it gives an answer that somebody wants as opposed to what actually happened. But whereas an as planned as built, you're actually starting from what actually happened and then looking at how it should have happened and then explaining the differences, and so in that way it's I'm not saying it's impossible, but you're then obviously people can overlook things, but if it's done right, then you can't just pick the events that you want. So that should, I think, answer your question.
Yes, thank you so much, John. Just one related question would be with respect to the types of delays that occur in a project. So, how have you seen, how does a contractor demonstrate, prove, or differentiate between the critical delays from the non-critical delays? And are there any overlappings? And basically, how does a contractor demonstrate that while putting it into the project records or the progress reports?
I mean, I'll probably start by saying what I see often is using the terms incorrectly. Delay, critical delay, and disruption are all terms that we see thrown around, but sometimes used interchangeably, sometimes used incorrectly in place of one another. And so, it's really important to understand that delay is different. Regular plain, delay is different to critical delay. Disruption is a form of delay, but again, it's subtly different. And so, a variation, let's say, the variation is instructed, that might cause some delay. That doesn't mean, it caused critical delay. It may have, but we need to, investigate that. If it just caused delay, then there may be a cost associated with that, and so a contractor may get some money, right? But they're not going to get time because it's not critical delay. Disruption, if we look at that, it comes down to a question of, well, can you prove it? And what is the actual disruption? So, I regularly see, disruption periods, big, long, large disruption periods being thrown out there. Oh, I was disrupted for 6 months because, I couldn't work in one area. Well, when you look at what actually happened, the men that were working on that area just moved onto the area, just further down the road or further up the building, or, they moved to a different area on the project. And so they carried on working and then only got around to coming back to that area, much later in the project. And so the actual disruption element is only very small. It was the time and period where they packed up from one area, moved to the other area, and then started working again. So again, with disruption, you can recover money, but not necessarily time. And then obviously from a critical delay perspective, again, if the employer caused that delay, then you can start looking at getting both time, and money. But again, you got to differentiate, between delay, critical delay, disruption, and then I guess something else that we see, and I see all the time in this particular region, is an employer awarding time, but not money. And if you think of that in terms of, delay, critical delay, then you go, well, you've given time, so, it should have been critical delay, but then they've not given the money for it. So you go, well, essentially what you're saying is, well, that must have been concurrent delay, with a contractor, and then that opens up, the whole world of and debate around concurrency. But again, we find that that's actually really unlikely that it was, concurrent for these big long, periods of where, time but not money are awarded. And so the reality and the actual position is actually quite different.
Yes, thank you so much, John, for that clarity. Just if we move on to liquidated damages portion, Rishabh, I would like to ask one question. What do you think are the legal requirements under the laws in the Middle Eastern region with respect to the actual losses, with respect to proving actual losses to claim liquidated damages from an employer's perspective? Where does it stand?
Thanks, Sharda. Well, liquidated damages in general, at least I've seen that not only in the Middle East, but even back home in India. You can't simply claim liquidated damages because there is a clause saying you're entitled to it. You'll have to prove delay, the existence of delay, and you'll have to prove that you suffered some loss. It need not be very specific, but you have to prove that you've suffered some loss. That's generally how it is. But if you come to the Middle East, because of the way the good faith principles work in the Middle East, courts very often have actually reduced LDs and even increased if the loss suffered does not exactly commensurate with the LD amount. So, for example, if there's, say, a very small delay, but the LD amount is exorbitant in comparison, or it seems more like a penalty and nothing more than that. Courts have reduced the amount of LD, and in terms of proving, I recently came across a judgment in Oman where the court has actually held that the burden of proving the loss is on the party that claims that there was no loss. I found that quite an interesting situation, because that's a very hard thing to do. You have no access very often to the other side's financials, and to prove that is significantly difficult. You can manage to do it in certain cases by getting in some data from the market, or showing that the project, depending on which situation you're in, but the project was not necessarily commercially viable anywhere. Or if you're, say, for a subcontractor, you're able to show that there was no penalty suffered but from the employer on the contractor, which is your client. So you really have to. It'll take a lot of effort, a lot of information you can get even in disclosure for this.
Okay, thank you so much, Rishabh. Just a similar claim, not a similar claim, but a claim that a contractor claims for, that is associated with the extension of time claim, becomes the prolongation cost. Sean, I would like to understand from you that as an arbitrator, how would you determine the prolongation costs to be awarded to the contractor? Is it based on the actual number of delays that occurred in the project and the corresponding cost that should be awarded according to that, or based on the actual costs incurred during the prolonged stay at the site?
Okay, before I deal with that, let me just pick up a point that Rishabh made about liquidated damages. What he said is absolutely right, and those on the call may want to note down two things. Firstly, Article 392 of the UAE Civil Code, which specifically authorizes courts to reduce LAD payments to a level which reflects actual loss. There's some interesting debates about how Article 392 applies. What it talks about is making an application to the court to reduce such payments. And sometimes an argument is, well, the other side haven't made such an application, and so that doesn't bite, and that gives rise to some interesting arguments. But that article doesn't have an awful lot of academic writing surrounding it, but it's clear from the article that this is a power within the UAE code. In any event, that article probably just codifies a Court of Cassation case 138/94, where the Dubai Court of Cassation recognized that the court has a general discretion to reduce damages mentioned in the liquidated damages clause down to the actual level of damage incurred. So I think Rishabh is absolutely right that both the Court of Cassation and the UAE Civil Code recognizes the right to reduce such damages. But the other thing he's right about is that's quite a hard argument. I have seen the argument run on a number of cases. I think in the last 5 or 6 years, I've seen the argument run in 6 different cases that I've been involved in, and has worked in one. And has worked in that case because it was absolutely clear, and that we, the defendant, could demonstrate that the claimant plainly had not suffered any loss. But I think most tribunals are looking for clear evidence that that's the case before they will before they'll exercise this discretion under Article 390 to reduce the LADs. So just to make that point. To take up the precise question you asked me, Sharda, is how are tribunals going to approach this? Well, the starting point is, of course, the contract. What does the contract say should happen in cases of prolongation? Sometimes contracts will say in cases of prolongation, the contractor's entitled to cost with a capital C, and then cost is defined quite carefully in the contract conditions. And sometimes the contract will say they're entitled to cost plus overhead, and then there's a whole debate as to what overhead means in that context. And in some cases, though it's pretty unusual in my experience, the contract will actually set out rates for this, in that it'll say something like, if you're prolonged, you're entitled to your cost, and then you go and look at the definition of cost, and the costs are defined as the amount of man hours that you have wasted or that you've had to stay there for extra times a particular rate in the bill of quantities. So the starting point is always, well, what does the contract say about all of this? Subject to that, how I think most arbitrators will approach this is to be wary of an argument that says, well, we have had to stay on the site for 6 weeks extra, and therefore we are entitled to the 6 weeks of extra cost that we incurred at the end. And the reason why arbitrators are wary about that is they'll scratch their heads and say, well, hold on, the reason you're having to stay an extra 6 weeks at the end of the project is because of delays that were actually suffered during the course of the project. And surely the the actual additional costs you've incurred are the costs you incurred in those days of delay during the course of the project. And so most arbitrators, I'll come back to what I mean by most arbitrators will say, let's work out when you actually suffered these delays and then work out what costs you were incurring on the days that you were on the project, but you weren't advancing. There was a critical delay being caused, and we'll add all of those up. And that reflects the actual position in the case law in England and in Australia and in Ireland, for what it's worth. Let's say that's how you should do it. Now, I say most arbitrators because that has kind of become the standard approach whenever you are assessing prolongation costs. But I have come across arbitrators who will effectively say that's just too hard. We just don't have the records to do that. Why can't we take as an approximation the costs you were incurring at the end of the project, and will not be dissuaded from that? So the short answer is, I think, threefold. Firstly, you look at the contract and apply that. Secondly, if the contract isn't very clear about it, or even if it just says you're entitled to your costs, whatever they are, what you're seeking to do is to identify the costs you're actually incurring in the days of delay, as opposed to the end point, whenever those you just end up on the site for longer. But the third point is that's not a universal approach by arbitrators. Arbitrators sometimes do approach it in a slightly different way. But just as I'm giving this answer, can I just pick up on a point that I can see has been made in the chat, where people are asking about, in particular, how things are approached in the Kingdom of Saudi Arabia. And one of the attendees today has pointed out that the tradition in Saudi Arabia in the court system is for the court to appoint its own court-appointed expert to assess such things as prolongation costs, and has pointed out that as more and more kind of international firms move into Saudi Arabia, they're saying to tribunals, well, don't do that, let us each have our own expert, and asks about the panel's experience of that for such things as assessing delay and prolongation costs. I think the first thing to say is that I think the person who's put the question in the chat is absolutely right. That is now what is happening in Saudi Arabia, where firms coming in are saying to arbitrators, let's not just appoint an expert to tell you what the answer is. We want our own experts, each of us, to do battle on this. There's an interesting question as to whether that's a right or wrong way to approach it, because it is different than the tradition under Sharia law in the Kingdom of Saudi Arabia. In defense of it, I guess I'd say that the experience of most people who've done these cases is that if you have the tribunal appointing its own independent expert, and the claim's a big one, then it doesn't save money, because each side then has to appoint its own expert to tell it what points it wants to put to the arbitrator appointed expert. And so instead of 2 experts having to be paid for, you end up with 3 being paid for, 1 by each party to help them deal with the claim, and then the expert appointed by the arbitrators. And the second point of defense is anybody who has done, and with all respect to John here, anybody who's done any of these cases has sometimes come across delay experts, and you think, well, you're just wrong in terms of how you've approached this. What you've said just doesn't reflect what I know is in the documents. And I think there is a concern that if arbitrators simply appoint their own experts in such things as prolongation costs or delay, that in a way they're just delegating the task of deciding those things to that expert, and that expert will be very difficult to shift from their initial view once they express it. And I think people are concerned about that. You know, you want to choose your own arbitrator, you want to choose somebody who's going to listen and take account of what each party says. And I think there is an overall concern that if arbitrators appoint their own experts, well, in a way, they'll just do what the expert says, because why appoint one and then not listen to the expert? And so just to deal with the point on the chat, I think that's the justification many people feel for saying to arbitrators, well, don't appoint your own expert, let's appoint 2 experts and then the truth will emerge. You decide which of them is correct about which. I say all that respecting the fact that that's different from the traditions in Saudi Arabia going back, and in fact Dubai and lots of places in the Middle East going back years. But that's why I think people doing these big disputes are trying to develop the practice in that way, because they're worried about duplication of costs and they're worried about not getting a fair hearing if the tribunal appoint just their own expert. So there you go. That was a bit of a long answer, for which I apologize, but I just wanted to pick up the point in the chat.
Yeah, thank you so much for taking that one up, Sean. Another question that I see in the chat, Philip asked, may I direct this question to Rishabh? He asked that can the monthly progress report be challenged by the contractor or client at a much later date? Example, 4 months after the date of the report.
Well, the answer in short is yes. But it really depends how and why you would like to challenge it, because you know, and the timing of the challenge, because if you decide that towards the end of the project, or closer to a dispute, or when you're in a dispute, if you start doing something like that, the tribunal will of course look at it with some suspicion. Second, what exactly is your challenge? If you're unhappy with a particular point, how have you dealt with it? Secondly, if you're doing it 4 months later, you also have to factor in what's happened the next 4 months. Because if there is incorrect reporting in month, say, of January, and you want to decide to make some objections in June, the reports of February, March, April will also be relevant, because they might be repeating what was already said in January in terms of levels of progress, for example. Also, I have seen a case with terrible reporting, because the percentages of completion that were shown changed with each report. And when I say changed, they went up in some and went down in the next one, and then went up again. It was really poor reporting. The client's explanation was this was what eventually was agreed very often, that there were discussions and they agreed to amend the reports in this manner, but none of this was in writing. So it raised a lot of questions. So you can challenge, but how you do it and why you do it is really important, and it has to be done in a very sensible manner and looking at things as a whole. I hope that answers.
Yeah. Thank you so much, Rishabh. There's another question that's there in the chat. Joseph asked that, is a contractor entitled to slow down the progress if the employer withholds the delay damages? I'll have a follow-up question on this, which I would like to understand from John. That do you see that if in any case the contractor slows down the progress, do you view this as a critical delay that would be attributable to the employer?
Yes, I think this touches on a point that Sean made earlier about, records, records with this. If you're going to slow down, you want to make sure that that's recorded and explained, that, you are doing it for a very specific reason. Okay, if I was a delay expert and I'm going to come along after the event, where I've got a period of slow progress, and going to make the leap to assume, that, oh, they must have slowed down because, of X, or because, they were being, delay damages were withheld. If I've got no records to back that up, that's going to be a hard sell. Whereas, I'm not going to comment on whether they're entitled to. I think that's a legal point. But you know, if they are going to, from a delay in programming perspective, in terms of, you know, from my side of things, if you're going to slow down for, you know, for a reason, you know, make sure that that is explained and very well documented. Yeah.
So far as the entitlement is concerned, Sean, would you like to take that up?
Yeah. So this is this is often a subject of a real debate, because non-payment issues in big projects are a significant thing. There's two things to say. Firstly, the contract may well provide a contractual remedy entitling a contractor to suspend performance of its works if it isn't paid properly. And so anybody who is thinking of slowing down or suspending performance of the works should look at their contract and see, is there a contractual entitlement. In addition to that, my recollection is it's Article 247 of the UAE Civil Code, and there's similar bits of the Omani Civil Code, allow a party to not perform their obligations if a reciprocal obligation is not performed by the counterparty. And often a contractor who is not paid in accordance with the contract will seek to rely on Article 247 of the UAE Civil Code in particular, and corresponding bits of the Omani Civil Code and the Civil Code of the Kingdom of Saudi Arabia, to justify this and say, well, your payment to me is a reciprocal obligation. I'm therefore entitled to not perform my obligation to perform the works as diligently as I would, or indeed to stop works. But it's often leads to real disputes. You know, there are disputes about how, if there isn't right under the contract to suspend the works, how does that feed into Article 247? There's an article about whether payment can be regarded as a reciprocal obligation, such that if it's breached, you're entitled to slow down or suspend your works. There's a whole lot of debate about that, but the direct answer to the question is often yes. If you're not paid properly, you are entitled to suspend or slow down the works, but you need to look at the contract and use your contractual remedy for that if you can. And if you're going to rely on the likes of Article 247 of the UAE Civil Code, you should recognise that that's going to be controversial and could end up in real debate about whether you were entitled to use that article in that way.
I see that with just 2 minutes left for the webinar, but just a follow-up related question to this that I had in my mind was, in a situation when there is a slowdown of work and there are reciprocal obligations, is it likely that the project would be rendered to be considered to be a time at large? And what effect does it have upon the completion date of the project in case there is a slowdown by one of the parties?
Rishabh, do you want to deal with that one? Or do you want me to?
Sure, I think you could go ahead, Sharda.
Sharda, just ask me the question again to make sure I understand it.
What would be the effect on the completion date of the project in case a party decides to slow down the progress of the works? Say, for example, because the employer is withholding the delay damages.
So that's the hardest question you've asked me so far. If the contractor slows down the progress of the works and he's not entitled to, because either there's no contractual right to do so, or Article 247 does not permit him to in those circumstances. So if in that situation, if the contractor slows it down without being entitled to, the delay would be for the contractor's account, and he would not be entitled to an extension of time for it. If the contractor slows down or suspends the works because of non-payment, I strongly suspect that most arbitrators would say that the contractor is probably entitled to an extension of time if he can show that Article 247 applies. But there may well be a real debate about the extent to which the contractor can get prolongation costs in that situation. Because most arbitrators might think, well, it's up to a contractor to have sufficient cash flow to do the job. If he really runs out of cash because of flagrant non-payment, I think most arbitrators would say you should get time and money. If the contractor slows down the job because of non-payment, despite really being able to get on and do it if he chose to, I suspect most arbitrators would say, okay, we'll give you an extension of time for that, but you're not going to get prolongation costs. And I can't really point to a scientific legal analysis to show why that's why most arbitrators would end up at. I can only point to doing a fair few cases in the region and thinking that's, I think, how most arbitrators would try with the Justice of Solomon to arrive at a fair outcome to that situation.
That would also answer one of the questions in the chat, where what in the event if not paid properly and you cannot afford to continue as required due to cash flow issues. So if this becomes one of the reasons for slowdown in the work,
well, I think,
what is
I see that question in the chat, Sharda. I think it goes back to my previous answer, my previous set of answers, in that if the non-payment is, if as a result of the non-payment, the contractor can find himself able to rely on Article 247, then he's fine. But if the contractor can't rely on Article 247 because of something in the contract, or because the arbitrator takes the view that payment is not a reciprocal obligation, then the fact that the contractor's run out of money won't help him. I'm afraid in this, there's not one answer fits all for every single one of these disputes. You're going to have to look quite carefully at the facts and the contract to work out what an arbitrator is likely to say at the conclusion of it. But I would say this, that if the non-payment is flagrant and continued, and the contractor runs out of cash, it's likely that most arbitrators in the region are going to think, well, the contractor should at least get time as a result of that and shouldn't be held accountable for that. But it will depend on the contract and the surrounding circumstances. That's my view anyway. You can't hold, nobody on the call can hold that against me if I end up arguing the other side of that in some case against you.
all right? Thank you so much, Sean. I'd like to thank John and Rishabh also for their insights. If Dan can take over from here.
Thank you very much, Sharda. And just to finish today, I would like to say thank you very much to Sean, John and Rishabh for their insights and expertise today. We really appreciate your time and for being with us, and Sharda for moderating today as well. Thank you to our audience for being with us today. We really appreciate your time being with us, and we hope that you have a lovely rest of your day. Thank you and goodbye.